Yes, yes.
Yes. Before Lordship looks at it, well, my first point is this. Once a law of the land is declared by the Honorable Supreme Court, what is the effect of it? Keeping in mind two dates. Date number one, September 2022, the writ petition was filed. Precise date is 12th of September 22, the writ petition was filed. And the
Yes.
Honorable Single Judge's order is 12th of May 23. The consistent view of the Honorable Supreme Courts, as I have brought three settled principle, when a writ petition is filed, the litigators, everyone's right is crystallized the day the litigation is filed. Precise citation on that is rights of the 2003 1 SCC 726, paragraph 7. 2003 1 SCC 726, paragraph 7. The short portion. Having heard the learned counsel for the appellant as also the learned counsel for the state and the private respondents, we are satisfied that the appeal deserves to be allowed. The ordinary rule of litigation is that the rights of the parties stand crystallized on the date of commencement of litigation. Lordship may kindly. And the right to relief should be decided by reference to the date on which the petitioner entered the portals of the court. A petitioner, though entitled to relief in law, may yet be denied relief in equity because of subsequent or intervening events. That is the events between the commencement of the litigations and the date of decision. The rest portions, I need not. I am only on the point of crystallization of the right of the writ petitioner in September 2022. Now, this point, as I said, it is a very consistent view. It is our court. It was by Honorable Justice Dipankar Datta's judgment, sitting in the division bench, 2018 SCC Online, Calcutta, 12185. 2018 SCC Online, Calcutta, 12185, paragraph 5. This is even tweaks little bit, that it is not only from the date of crystallizations, one may not even get the relief if in the intervening period anything happens. Paragraph 5. Law is well settled that although ordinarily right to relief relates back to the date of institution of the proceedings, that is crystallization in September 22, the remedy of a writ being discretionary, in an appropriate case, relief may be declined if during the pendency of the proceedings before the writ court there is a change of law which makes the relief incapable of being granted. The same thing has also been echoed by the Honorable Supreme Court. This is the last judgment on this. 2020 9 SCC, page 1. 2020 9 SCC, page 1, paragraph 101. This on the point, if there is a change of law, an appeal is pending, there is a requirement of take note of that change by the Honorable Appellate Court.
Yes.
Paragraph 101, well, this is a quote from the another judgment. In Lokkinarayan Gui versus such and such, it was laid down that change in law during the pendency of the appeal has to be taken into consideration. Thus, that a change in law during the pendency of an appeal has to be taken, practically the same thing. Lordship may skip that. Thereafter, just under 10. If the new law speaks in language which expressly or be clear interdependent takes in event pending matters, the court of trial as well as the Court of Appeal must have regard to an intention so expressed, and the Court of Appeal may give effect to such a law even after the judgment of the Court of First Instance. My first fundamental point is this. 2016 rule 6.2 and 6.3 has been interpreted by the Honorable Supreme Court in April 2025 in two clear categories. Before saying anything, I will show three paragraphs. Thereafter, I would say what, my lord, what is my submission. Kindly take, my lord. Kindly take my note.
Yes. Which judgment you are?
Yes, my lord.
Note.
The note contains, my lord, the formulation which is directly taken from the Honorable Supreme Courts.
Yes.
Yes, my lord, I say that 2025, kindly see Roman 1, two categories have been formed by this judgment. True, after the single bench judgment, correct. That is, one is just an untrained candidate who are the writ petitioners and who could not get themselves trained by April 2019, which is one of the most important dates. And Lordship, straightway kindly come to paragraph 26. Three paragraphs I would be relying, two for us and one for them. Plus 26 of 2025, Lordship has copy of the judgment. I have extra copies also.
2025.
I last question I gave, but there is no difficulty. But I brought the another extra copies.
এখানে থাকবে তো?
Lordship need not waste any time. There are copies. এই যে দেখুন 25 SCC online SC 722 722 Justice Gawai. Yes. Well, before placing the judgment, my respectful submission is this. By this judgment, which is, my lord, which is a law under Article 141 applicable to, as the Honorable Supreme Court held, for more than 12 lakhs pan India, a window was created and recognized by the Honorable Supreme Court having three fundamental pillars of the window. If anyone fulfills the three conditions of the window, as I said metaphorically, he becomes a butterfly. Well, I am using the caterpillar as an untrained and butterfly as a trained. The Honorable Supreme Court's law.
Mr. Dhar, what is the point you are arguing? Reference to what? All right, crystallized on the date of filing writ petition. Then
Yes.
what is your argument?
My argument is this: by virtue of the Supreme Court judgment, once the conditions are fulfilled by April 2019, that is pre-filing of the writ petition.
Where do you find that date? April 2000?
Yes, that date can be found in paragraph 26.
Of what? Paragraph 26 of?
Date is one pillar of the window.
Paragraph 20.
Paragraph 26 of Kaushik.
What you are arguing?
I am arguing this.
Go to metaphorical examples. Tell us what you are arguing.
My submission is this. The basic premise of the learned single judge was, we are untrained.
Yes.
And some others are trained.
Yes.
So around 10,000 trained.
Trained is not involved in.
Yes, I'm saying. So we are untrained.
You are untrained.
At the time of recruitment. That was the premise. And therefore, no protection to us because we were untrained. That's the premise of the judgment. Because we are untrained and because corruption happened as perceived by the Honorable Single Judge, therefore, untrained candidates do not deserve any justice or equity. Their termination is the right course of action. And following action, what should be done? That was the basic premise. The judgment of the Honorable Single Judge has two categories. I am not touching the trend, clearly said. Irrespective of the fact that interview, test, whatever, though I have all my independent points that this is just a perception, not correct. Irrespective of the fact, everything was in the similar manner. But because at the time of recruitment, under Rule 6.3, I was an untrained candidate,
Yes.
admittedly.
Yes.
So that was the premise of the Honorable Single Judge, to make a distinction between trained and untrained.
How does that affect you?
Yes. If I put
You are also untrained people.
I am untrained,
Yes.
but I am no more untrained after 19th April 2019. That is the law of the land declared by the Honorable Supreme Court after setting aside the judgment of our court.
It's not the ground of the cancellation of the appointment.
Exactly. That's my
Then
point.
why you are arguing that?
I am arguing because the writ petition was not filed.
Petition said that I am untrained.
Yes.
You are untrained.
Yes.
You have been favorably dealt with by the board.
But when the writ petition is saying so.
That was in September 2020.
Yes, that.
Now, whatever right crystallized in your favor, we are not on that. You are asking us to examine whether the direction for cancellation was justified.
Absolutely. Kindly look at this way.
So please make it within those parameters.
I am coming to that. Kindly see that. This is most likely, unless I'm missing, either I'm missing completely, or there is such a fundamental point which has been missed completely by the. Allow me to reframe it. All I am saying, by virtue of the Honorable Supreme Court judgment, which is the law of the land. Kindly forget it that I understand this law of the land was declared in April 25, but Lordship is hearing today. Lordships may not ignore this judgment. And this judgment, Supreme Court clearly held that by 19th April, I ceased to be an untrained. I was surprised when I read it. That was my first reaction. I know I'm doing something like adventuring, because this point was never been there. Of course, it was never been there. But
now, then what is the analogy? Then after April, what is your character?
Yes, after April, if I fulfill those three conditions, the condition number one, that I have to be in service by August 2017. That's the Honorable Supreme Court held. Condition number two, during service, I have to complete that through NIOS only. And third condition is, I have to complete that course by 19th of April. And thereafter, the Honorable Supreme Court said, anybody who is not fulfilling, or fulfilling only one condition of fulfilling after April 19, he will not get this benefit. Effect is, after April 19, because of the fulfillment of these three conditions, declaration of the Honorable Supreme Court is, you become at par with the trained. That is what Rule 6.3 of ours. Or I would have faced the dismissal. Now, this declaration.
Have they made this point in their writ petition?
No, why they will make? They will not make it. I say that, kindly visualize this way. They filed the writ petition in September 2022. Now, in September 2022,
your contention is, by the cutoff date, I have now become a trained candidate. I have been appointed. Untrained cannot disturb my appointment, because now at this juncture, I am trained. That is your argument.
Yes, plus by the same judgment, the Honorable Single Judge has said, I am not touching trained candidates who were trained at the time of recruitment.
Yes.
Now,
all right, your argument is, by the cutoff date, I have become trained. You cannot challenge my appointed now in this course, in these facts. By
telling me that you are an untrained, all I'm trying to say that had the writ petition being filed before myself become,
paragraph,
yes, paragraph 26, 3 paragraphs. Kindly see 26 first.
Yes.
Well, this is, Lordship has got 26.
Yes.
It can thus be seen that this court observed that since the time gap between the direction issued by the central government and 31st March 19 was only about 18 months, the period of the course was reduced from 2 years to 18 months. It can further be seen that this court recorded that around 12 lakhs, such and such, in-service elementary, in fact, we also fall under 12 lakh, elementary teachers had registered and made payment on the NIOS portal as on 30th September 17. Not only that, but this court also observed that the NCT recognition order dated 22nd September 17 was, kindly mark this, only for those untrained in-service teachers in governmental aided, unaided private schools who were appointed on or before this condition, 10th August 17. So anybody after 10th August, no. Pertinently, this court observed that the entire scheme was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualifications prior to 1st April 19, they could not have continued to remain in service and would have faced dismissal. Kindly thereafter see 33. Or before 33, sorry, paragraph 28, last sentence. Writ petition would be attracted under that. Because there is the direction by the Honorable Single Judge, hold another examinations, giving them time to do the training, which is completely contrary to 28. 28, last sentence. Any other candidate who was not in service as on 10th August 17, that is writ petitioners, cannot be considered to be at par with the 2 years DLED. Kindly come to 33 thereafter. As observed herein before, as observed herein before, it is clear that the judgment of this court in the case of Jaivi Singh unequivocally held that the entire scheme emanating from the NCT recognition order dated such and such was for the purpose of providing a window to the in-service teachers in as much as unless they would have acquired requisite qualification prior to April 2019, they would not have continued to remain in service and would have faced dismissal from service. As such, this is the condition. Any teacher who was in service as on 10th August 17 and who acquired the qualification of DLED by way of 18 months program through NIOS prior to 1st April 19 is a valid diploma holder and at par with any other teacher who has been completed the 2 years DLED program. My respectful submission is this. Had the writ petition been filed prior to 19, no difficulty.
Have you taken? You couldn't have taken this ground in the appeal.
But that is.
You are now going beyond that.
Your Lordship,
new points.
Yes, Your Lordship,
this is not the subject. You have not taken this ground in the appeal.
May I say this? Would Your Lordship genuinely think that I should not take this point? Then I will not say any single word.
That is choice is up to you, Mr. Dhar. You are arguing something
which
is not there.
May I say this?
Not even there in your appeal.
No, that is there. May I say this?
Where is it? Show us one ground that you had a premeditation that Supreme Court in future years will decide.
Kindly allow this. Kindly allow.
Unnecessarily elongating the issue.
This is not unnecessary.
This is because that is one say you are saying your writ petitioners have not pleaded anything and they are taking this. Now you are saying that no, though I have not pleaded, I will take this.
No. Kindly allow me to say what I'm.
I have allowed you. Come to the next point.
But I will come. But I have not finished this point. Lordship.
We understood.
I am not join the practice for 1 year and I will take all the irrational things. Lordship is dealing with the lives of about 2 lakhs persons.
Please don't remind us of our duty and obligation.
So kindly,
we have put your question, you have failed to answer that. But still, we have heard you on that point. You proceed to your next point.
I'm answering to Lordship's query. Lordship's query whether I have taken this point or not. Kindly see the date of the judgment. Yes. It was of April 25.
You could not have taken.
So therefore, we don't have a time machine.
So then why you
were not even parties? Point? Kindly look at this way. No, Lordship, this is unfair. I was not made as a party. I had to go before the Honorable Supreme Court. Supreme Court directed that all contentions have to be made. In the meantime, Supreme Court declared a law. Lordship do not want to see it. Can this be a law? Can this be a law?
What we are doing?
My interpretation, kindly see, my interpretation may be wrong. But to tell me, go back to the time machine. This judgment was delivered in April. I am trying to get the benefit of the judgment.
Don't misquote us. Yes. This point you raised on the earlier occasion.
This
he said, Mr. Dhar,
yes.
Please restrict yourself on the basis of the materials which are there. You insisted that I should put this point. You have put your point. We have taken note. Finished. Come to the next.
I have taken this point in a sense that under 6, can you take the rule, my lord? Can you take the rule itself? Because this is not that something new has come up by the Supreme Court. It was there very much part and parcel of the rule. Every time my endeavor is this. Kindly, my lord, I may not be able to, my lord, express myself. But my endeavor is this, that once a litigation is filed, then rights of the litigators is of that date itself, and that is 22. And the window created by the Supreme Court based on the NCT several orders, that window is finished by 19. Now, right before the learned single bench, this judgment was not there because there was a contrary view in present. But today, all over India, every teacher who are acquainted and fulfilling these 3 conditions, they are treated at par because of paragraph 33.
We understood you.
And
what more you have to
now, Lordship, kindly look at this. Kindly see this. Kindly take, my lord, the copy of the rule, possibly with your lordship. Kindly take the rule. Rule 6.2 and 6.3. Copy of rule.
That has to be done within 2 years.
Because that this is directly recognition of rule 6.3.
Yes.
Because
by rule 6.3, they have completed, they have those appointed, they have completed the trade.
But we did not have any seal of the Honorable Supreme Court. All I'm trying to say that we did not have a seal of the Honorable Supreme Court of at par. Now that seal came in 2025, which had a retrospective effect in understanding of the law before a Honorable Division Bench, when this Honorable Division Bench is deciding. This is my point. My first 3 judgments was that this is during pendency.
Yes.
This copy of the rule, lordship might be having this. 2016. Well, I have a separate copy also. Lordship might have marked.
Yes. Yes.
Yes, lordship, kindly see 6.2. I'm not reading entirely because it has been read only the last line. Read with relaxed qualification issued by the ministry from time to time and past that period. So, and 6.3, that 2 years.
Yes.
So I will conclude this point by after saying this. So lordship, kindly think this, that there was an existence of contingent condition to be fulfilled under 6.3. I have fulfilled by April 19. Having fulfilled by April 19, there I use my metaphor, I have become a butterfly, no more a caterpillar. But this single judge has treated me as a caterpillar.
Yes.
That is wrong because of paragraph, lordship, kindly take the paragraph 22 of the Honorable Single Judge's order. It goes directly contrary to this, the law declared by the Supreme Court. Kindly take paragraph 22 at page 624 in the paper book.
Yes, read it. Third.
Paragraph 22 runs completely contrary to paragraph 28 of Kaushik. Because paragraph 28, the Honorable Supreme Court had held, this is only available subject to fulfillment of 3 conditions. But here the learned single judge gives a separate condition. Kindly look at, the board shall immediately arrange for a recruitment exercise for candidates who are untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime, within a period of 3 months from date. This is totally going contrary. From date only for the candidates who participated in 16. Kindly have a look at paragraph 28 of Kaushik. So therefore, learned single judge gives time, even 3 months more, much after 19.
Yes.
Kindly take the one sentence of paragraph 28. The last sentence of 28.
Yes.
Any other candidate who was not in service, that's a writ petitioner, on 10th August 17 cannot be considered to be at par with the 2 years DLED. So therefore, window was there, 3 conditions were there, it is sealed. Nobody after April 19 cannot make himself trained. Not possible as long as this judgment stands. I'm over on first point. My second point. If I use this word, the Honorable Single Judge completely ignore the statutory word natural in Rule 2C of in teaching test. Kindly see 2C. 2C is never a test.
Yes.
Well, my second point is the honorable single judge completely ignored a particular word in the definition of 2C, which changes the entire color of this. Kindly see 2C. 2C never says about the aptitude test. It's a natural. First, let's take it.
Yes.
Well, a definition is aptitude test means a test, kindly mark, to assess natural teaching ability of a candidate. It is not a separate test at all. Kindly take the examples of we often have in our college, the extempo debate competitions, where the judges take a decisions based on assessment of overall presentations, content, maybe oratory. So assessment has to be under two categories: vivavocy and the natural ability of a candidate. Sorry, natural teaching ability. Well, I was trying to understand what does it mean of the natural, because what's the difference between? Lordship kindly takes the blacks. Lordship may take us a very, very common understanding while Lordship hears out the matter from the advocates. There are content, there are laws. Lordship looks into that. Simultaneously, Lordship also sees, I think this is a very, 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 as a Homo sapiens, we get that. The natural ability of the person, whether to communicate or not. So my submission is, it should be one test. In the test, there would be questions. While the interviewee answering the question, the interviewer would, in addition to the correctness of content, also assess, does he have a natural ability to teach? That's what 2C says. Lordship, may kindly have a look at the definition of this. In black.
Did your interviewers understand this?
Well, I will satisfy your Lordship.
Tested by persons who are not even qualified to understand that much of
Well,
things.
they understood. Well, one of the examples, Lordship may be shocked. Lordship may be
making an argument. Now you kindly go through the definition, and definition will show that it is not a segregated test. Interview and aptitude was said. It is only the nature of question which was put is to be different.
It is to be segregated assessment. Kindly visualize. I don't say that there should not be any test for natural ability. I don't say so.
We are asking you, was this done?
It was done. I will show from the evidence also.
It was
Lordship
done.
would be surprised. On every fact, I shall be satisfying your Lordship's conscience. I am not going to take any technical points. Kaushik was, of course, maybe a technical point. But most likely, I would be able to persuade your Lordship that on fact.
What is your argument to that? That interview and aptitude have to be taken in a composite manner?
I say this. How a natural ability can be assessed? Kindly visualize.
You tell us.
Yes. I say that if a test is exclusively for a test for judging natural ability, then you kill the naturality of it. Kindly think over it. Lordships are testing the lawyers. Whether Lordships require a separate test for the lawyers to understand the natural ability to communicate, or that is in the process in
Mr. Dhod, primary teacher applicants, they will understand so much. Your interviewers will answer this.
This is nothing
to
do
with asking us to go into the issue, the manner in which you understand the definition.
I'm saying that
it's unfortunate.
No, I'm not.
You are bringing in points which your board interviewers did not have that amount of intelligence, so to say, as you are arguing in this matter.
No,
not you are just because you are the arguing counsel.
No.
Whichever things you
they understood it. They understood it correctly, but they were not able to communicate it. They may not be able to say it as I am saying.
So you cannot communicate afresh on their part.
No, I will not communicate.
Please don't do it. You restrict yourself on the ground of challenge.
I am restricting, my lord. I am not making submissions which are not relevant. Kindly visualize this. Lordship has seen in the judgment anywhere that word natural has been used by the honorable single judge.
Don't do post question to us. You make your argument.
My lord, I say that. Sorry. That was my mistake. Sorry, extremely sorry. My lord, the honorable single judge. My lord, sometimes I'm so sorry. I shouldn't have. My lord, the honorable single judge in the entire judgment has not used the very definition of aptitude test. Two things are different. Assessment of aptitude test not done is one thing. An aptitude test has to be a completely separate test altogether is a different thing.
So you say they are intermingled.
Yes, because I also give an answer. Because preservation of the naturality. My lord, when someone is answering questions, kindly look at this way, my lord. There has to be certain amount of subjectiveness, or I can use arbitrariness. Subjectiveness is a better word. When a question is asked on geography, on history, on English, on anything else, if the answer happened to be the same, like a quiz contest, but how that answer is given, if the persons who are taking the interview, if they understand it, that's the natural ability. They would be the best person to assess it. Therefore, there has to be an assessment. Absolutely right, the honorable single judge on that. But to say that no, there should be a separate test altogether, like a separate day, separate test, that is incorrect.
That the court has not said. Separate day it should be held, it has not.
Court has said there was no aptitude test.
That is one thing of it. That aptitude has to be taken in a separate date. This was never the picture.
But that the lordship kindly take it.
Judge proceeded on the basis that when there are two faculties of mark giving, 5 for interview,
lordship may be shocked in the process that the honorable single judge has proceeded. Kindly come to page 615. A person was called, his English was not good, and the judge terminated his service there and there by a judicial order. At least in my last 28 years of practice, I have never ever come across this. Do I need to spend one sentence to say that this is so unjust? A person who is not a petitioner, who is not a candidate, who is nobody, he is called, his English was poor. So how many of us would actually lose our license?
Not the ground of challenge. That is not the ground of challenge.
Need not be. But that's the basis of 615.
Don't go into the conduct and the manner it was done.
I am not going. Kindly come to 600.
You point out the action, all right.
Yes.
Please don't go.
But that has been taken note of. Kindly take it.
The court had been unreasonable according to you. Finished?
No, if it is,
person doesn't know English. If he said that, go, I am terminating your.
If I finish in that way, then I actually finish. I am trying to survive.
What?
Kindly have some mercy also on us. There are two sides. There are both sides of a story. Possible that my story is not good enough.
Yes.
Kindly take 650. Kindly take two notes. There were 700 interviewers.
700 interviewers.
Total, approximately.
Where did you get that figure from?
I don't have, but I don't think.
Nowhere it is there. Yes.
But there has to be a number. But for understanding that 30 of.
Which page you are referring? Page?
Page 615. 30 persons were called.
650.
Yes.
Yes.
Now, Lordship may kindly first mark, I have calculated who said what, and what I have found, out of 30, going by the exactly recording of the judge, out of 30, 13 said no aptitude test. Kindly take number 1. Did he say that there was no assessment of the aptitude, natural ability? He didn't say so. He said there was no aptitude test because any common persons will understand aptitude test itself as if a separate test. So out of 30, 13% said no aptitude test. Kindly come to serial number 16. That's the reason I said this. Serial number 16 was Mr. Tushar Kanti Das, the unfortunate gentleman whose English was poor. By a judicial order, he lost his service. And that is page 616. Kindly see, the recording is evidence on the real question was not taken for special reason. Most likely, Lordship will kindly take my serial number 16. Tushar Kanti Dash, what is the evidence on the real question was not taken for special reason. Lordship has seen that. Now kindly see what is the reason, page 537.
Yes.
The reason was this teacher understands very little. He is a teacher of a secondary school. Kindly see. I find him wholly unfit for teaching job in a school. He has clearly stated that he does not know English. I do not know how he will develop teaching ability. Incidentally, he was a game teacher. Ability to teach a student. Hence, I recommend the West Bengal Board of Secondary Education to terminate the job of the deponent forthwith. If I have to spend one more sentence on this to say this is injustice, I feel extremely sad about it. A witness, no way connected with the case, was not able to. In fact, I got the judgments by the Honorable Supreme Court saying if somebody is not good in English, do not deprecate that. We are living in a federal structure. There are villages. Not everyone gets an urban education. And there we have.
What you are meaning to say, Mr.
I am meaning to say that
the judge was unreasonable. What is your argument, sir?
Do I have to? I say this. Yes, I borrow your lordship's word.
So if you say that this is an unreasonability, all right.
There is an unreasonability of a.
If for unreasonability you go for a predisposition,
no.
Then it becomes a bit.
May I say what I say? Can you see? I say that on a scale of unreasonability of 0 to 1000, it falls under category of 900 and plus. Had it been an unreasonableness of 0 to 100, possibly I would have ignored it.
Understand the backdrop in which it is being.
No, he is not a candidate. He is not a corrupt person.
How does that affect you?
It affects. Kindly come to 615.
Somebody has given me less numbers in the examination. If that is challenged.
No.
If the principal of the school is sent for termination, what effect does it have?
Yeah, explain how. Affectation is this. I decide the rules. I decide what should be the question. I don't read to see. I forget about the naturality of the test. So I ask a question. Was there an aptitude test? So that is a fundamentally flawed question.
Very good. That will be your argument.
Now, while I do
fundamentally flawed questions were put to the interviewers. Finished.
Well, it is.
Kindly see the conduct of the judge. Why, for that reason, one word person terminated. Not knowing English is not a requirement. I will cite Supreme Court judgment so that is beyond the scope and ambit of this matter.